After Professor Anaya, we have Inez Andrade, who is the coordinator of social standards at Cerrejón Coal. Now, Cerrejón Coal is one of the largest open-pit coal mining companies in the world. It is located in the department of La Guajira, in the north of Colombia, in close proximity to indigenous communities. Cerrejón is independently operated, and the three shareholders in equal measure are subsidiaries of BHP Billiton, Anglo American and Xstrata. The third panelist today will be Joan Carling, who is the Secretary General of the Asia Indigenous Peoples Pact, the AIPP, based out of Chiang Mai in Thailand. AIPP is a regional organization of indigenous peoples movements that is committed to the cause of promoting and defending indigenous rights and human rights, and it operates on a network basis. It has got 46 members from 14 countries, and it's a blend of national alliance and networks, as well as local and subnational organizations. Then we have Professor Megan Davis, who's a serving member of the UN Permanent Forum on Indigenous Peoples, and she's also Professor of Law and Director of the Indigenous Law Centre at the University of New South Wales in Australia. Now, Megan has extensive experience as an international human rights lawyer and participated in the drafting of the United Nations Declaration on the Rights of Indigenous Peoples. Our fourth panelist today, or our fifth panelist today, is Mr. Leo Crippa. Leo is Senior Attorney with the Indian Law Resource Center in Washington, D.C., which is a not-for-profit organization that was founded and directed by indigenous attorneys and experts, and which provides legal assistance to indigenous peoples of the Americas. Two other important people here to deserve a mention. We are delighted to have with us Mr. Pavel Sulyanziga, who is from the UN Working Group and who is also a former member of the UN Permanent Forum on Indigenous Issues and an advocate for indigenous rights in Russia. The order of play today is I'm going to ask each of the panelists to make opening remarks of no more than 8 minutes or so, and to speak to what they see as the key challenges from their perspective in implementing the UN guiding principles in relation to indigenous peoples. And then we'll open it up to questions from the audience. Now, as those of you who've been here for the last day and a half will know, that the only way to get an opportunity to speak is to put your name down on the speakers list. And for that reason, the next most important person is Eleonora Aggio. Eleonora, if you would just wave to everyone from there. Anyone who is interested in making or putting a question to the panel, they need to see Eleonora. The speakers list will be open until the last presenter stops speaking, and thereafter it will be closed. I would ask that participants keep your comments brief and to the point, and be responsive to what you've heard the panelists say. I will absolutely aim to ensure a balance of contribution from across the various groups represented here. And the last thing is just to say, if some of you have pre-prepared statements, please do share them with us, but I'd appreciate it if they weren't read out. If you give them to us at the end of the session, we will make sure that they are conveyed to the UN Working Group. With that, I will stop talking and give the opportunity to the panel, and I'll ask Professor Anaya to open the floor. Thank you.
Thank you very much, fellow panelists. Pavel Sulyanziga is a member of the working group. Participants represent UN member states. Can you hear me now? Yeah. It's right. You think I've never done this before? Anyway, thank you again, Aiden. Members of the working group who are present, Pavel, and fellow panelists. It's great to be here. It's a pleasure to be able to participate in this inaugural forum of the Human Rights Council on Business and Human Rights. I'm grateful for this opportunity to share some of my thoughts on the subject of indigenous peoples in the context of the guiding principles and the challenges that we face. First, however, I'd like to add my acknowledgement of the monumental work of Professor John Ruggie and others in launching the guiding principles. I join in celebrating that the development of the guiding principles, their endorsement by the Council, the establishment and work thus far of the working group to advance their implementation, and this forum open new and important possibilities for advancing the human rights of indigenous peoples and others within many contexts reached by business. Of course, as many at the forum have already remarked, and indeed the reason that we are gathered here is that there are many challenges ahead. And in many ways, as many have already said, the work is just beginning. In my work as UN Special Rapporteur on the Rights of Indigenous Peoples, I've been confronted by numerous instances of alleged human rights violations in connection with business activities, especially in the context of extractive industries that operate on or near indigenous territories. So I've dedicated significant attention to issues that are at the intersection of business and the human rights of indigenous peoples. My 2010 report to the Human Rights Council focused on the responsibilities of corporations in relation to indigenous peoples. And my last two reports to the Council are part of an ongoing study on the issues faced by indigenous peoples that arise from extractive industries. Excerpts from these three reports are compiled in a conference room paper and are available on the forum website. In my examination of issues related to business and human rights, I've observed a high level of acceptance by states and business enterprises of the guiding principle and their protect, respect, and remedy framework. However, I've noted significant ambiguity about the extent to or manner in which the guiding principles relate to the standards of human rights that specifically concern indigenous peoples. I have observed a pervasive lack of understanding, much less conviction, that the human rights that states are to protect in the context of business activities and that companies are to respect include the specific rights of indigenous peoples, in particular those rights that are affirmed in the United Nations Declaration on the Rights of Indigenous Peoples. I believe it should no longer be questioned that the state's protective role entails ensuring a regulatory framework that fully recognizes indigenous peoples' rights over lands and natural resources and other rights that may be affected by business activities, that mandates respect for those rights in all relevant state administrative decision-making and in corporate behavior, and that provides effective sanctions and remedies when those rights are infringed either by government or corporate actors. Such a regulatory framework requires legislation or regulations that incorporate international standards of indigenous rights and that make them operational through the various components of state administration that govern land tenure, mining, oil, gas, and other natural resource extraction or development. By and large, however, regulatory frameworks of this kind are still lacking in states across the globe. For their part, as affirmed by the guiding principles, business enterprises have an independent responsibility to respect human rights. And as I have detailed in my most recent report to the Council, and as indicated in the comment to Principle 12 of the guiding principles, the rights that corporations should respect include the rights that are specific to indigenous peoples. These rights are articulated not just in the Declaration on the Rights of Indigenous Peoples, but also in ILO Convention 169, provisions of various other treaties, including the Convention on Biological Diversity, and in several authoritative international decisions and statements interpreting provisions of core human rights treaties. The guiding principles clarify that corporate responsibility to respect human rights exists independently of states' abilities and or willingness to fulfill their own human rights obligations. This independence of responsibility notwithstanding, I have learned of numerous instances in which business enterprises engage in extractive industries that do not go further than compliance with domestic laws or regulations, regardless of the ineffectiveness of those laws and regulations for the protection of indigenous rights. Corporate attitudes that regard compliance with domestic laws or regulations as sufficient should give way to understanding that fulfillment of the responsibility to respect human rights often entails due diligence beyond compliance with domestic law. My examination of the issue confirms that there is need for change in the current state of affairs if Indigenous standards are to have a meaningful effect on state and corporate policies and action as they relate to Indigenous peoples. An initial step towards change of this kind would be greater common understanding among Indigenous peoples, governmental actors, business enterprises, and others about the existence and content of Indigenous peoples' rights and the means of their implementation. Without such understanding, the application of Indigenous rights standards will continue to be contested or ignored, and Indigenous peoples will continue to be vulnerable to serious abuses of their individual and collective human rights. I commend the work of the Council's expert mechanism on the rights of Indigenous peoples to advance understanding of Indigenous rights in the context of his business activities, including in relation to the guiding principles. And I believe we will hear more about this work from the chair of the expert mechanism, Chief Willie Littlechild, at the plenary of the forum later today. And I note that Chief Willie Littlechild is with us here this morning. Also towards this end, I have carried out a series of meetings with governments, Indigenous peoples, and representatives of business enterprises in order to listen carefully and draw extensively on views and experiences that all stakeholders share with me on this issue. I would like to warmly thank the Indigenous organizations, NGOs, business enterprises, and government and parliamentary actors that have facilitated and participated in these meetings in various parts of the globe. As a complement to these meetings, in the coming days, I will launch an online consultation forum organized around specific questions or issues related to extractive industries. And through this web-based forum, Indigenous peoples and others will have the opportunity to submit information on their experiences with extractive industries, as well as to respond to specific questions. I will also continue to gather and analyze empirical information on specific examples of natural resource extraction activities affecting Indigenous peoples during my ongoing work as Special Rapporteur examining cases of alleged human rights violations and in carrying out country visits. I hope that this work contributes to providing much needed orientation on the practical implementation of the guiding principles, especially in the context of extractive industries. I believe that new and different models and business practices need to be examined. Models that are more conducive to Indigenous peoples' self-determination and their right to pursue their own priorities for development. Such models could include genuine partnership arrangements between Indigenous peoples and corporations, or even models in which Indigenous peoples themselves develop their own extractive business enterprises, as many already have done. I intend to explore these possibilities further in my final report to the Human Rights Council. I would like to conclude by expressing my gratitude for the opportunity to participate in this panel, and I look forward to the discussion. Thank you all for your kind attention.
Thank you very much for those remarks. You've also reminded me that I was remiss not to introduce one other person in the room today. That's Chief Wilton Littlechild from the UN Expert Mechanism on the Rights of Indigenous People. Chief Littlechild will offer some reflections towards the end of this session on what he's heard from the panelists and from the assembled participants. And so I will be sure to protect a little bit of time to get those perspectives as well. If I could turn now to Inez Andrade, please do offer us your
Thank you very much, Aidan. It's an honor for Cerrejón and for me to be here today talking with you on this panel on the challenges of the implementation of the guiding principles in Indigenous contexts. As Aidan also mentioned in the introduction, Cerrejón Coal is an operation that has been working in Colombia, in the northern part of Colombia, for almost 30 years. We are an operation, an integrated operation of production, transportation, and shipment of coal, of thermal coal. And as many other companies, coal companies and extractive companies, we face many challenges, but at this moment I will only focus on the specifics of the Indigenous, of the challenges we face by operating in an Indigenous context. I would also like to mention that I will mention some of the challenges we face in this specific area, and then I would go on to mention 5 specific challenges that we have identified in the implementation of the guiding principles. Just to explain about the situation and the context where we operate, I would like to mention that most of the YU is the indigenous group that surrounds most of the area where our mining operation takes place in the northeastern part of Colombia, and they also inhabit the northwestern part of Venezuela. They are the largest indigenous group in Colombia, approximately formed by 270,000 members, and combined with the population that lives in the part of Venezuela, this indigenous group sums around 450,000 members. It's one of the largest and growing communities, indigenous communities in the country, different from other indigenous groups that we know that are reducing the number of their members. But similar to the rest of the indigenous groups that live in Colombia, the YU are extremely vulnerable if we measure and we look to the indicators on poverty indicators, unemployment rates, and also rates on illiteracy, among others. So they do have common similarities with the rest of the indigenous groups in the country. As I mentioned, Cerrejón has been operating for 30 years, and even though we believe that since the very beginning of the operation, Cerrejón tried to have to implement leading standards in environmental issues and applying safety measures for employees, and also following the Colombian law very strictly and trying to adopt good neighbor attitudes. We really must admit that at those initial stages during the 70s and 80s and even further, things were not done as correctly as they should have done if we measure by today's social laws and social issues and by the current social standards that we have in place. So we do recognize that during those times things were not done as they should have. The interpretation at that time was that if the company followed the law, all the company's actions would be legitimate. And our experience has shown us that that is really not enough. Following the law, even though it may be pretty good in Colombia, at least in some stages, we really believe that companies need to do much more. Some of the challenges that we have seen from operating in this indigenous context is the complexity, is the characteristics of the YU organization. This is a community that is decentralized. They have 22 reservations and several clans, almost 20 clans, formed by each one of them, formed by many families, each led by the leader of the family, which is difficult for the company to address because they do not have a centralized focal point to make decisions. So that involves a challenge for us, for the company. They're also poly-residential, which means that they constantly move from one place to another depending on weather conditions. And they move in a very vast area of 15,000 square kilometers of very arid and difficult ways to access the land. So that imposes difficulties for the company. But we also must recognize that the company itself had many difficulties within the company to address them. We had a very small engagement team to talk with the YU communities. We were not prepared. We had little resources, and we lacked a structured vision towards the community. Recognizing this situation, Cerrejón during the 2005 approximately decided to make some changes. Things were not the same. So new standards, new laws were coming into place, and we decided to have an independent look at how the company was implementing and developing its practices. So we called an independent panel to review our performance, and with that we made some changes that included corporate culture, adopting social standards, and new ways to engage with communities, not only Indigenous, but the rest of the communities that surround the operation. We also created a system of 4 foundations, 2 of them addressing specific impacts with the Indigenous communities, to address their most pressing needs, water and the strengthening of their culture. And after that, the company decided to strengthen the social engagement team, and now we have more people being able to engage on a permanent basis with the Wayuu community. With that, I would like to go on and mention 5 of the challenges we have identified in the implementation of the guiding principles in this Indigenous context. The first one, as I mentioned, is dealing with the legacy issues. The guiding principles recommend that the due diligence process should be started at the very initial stages of any project, but we have been a company operating for almost 30 years. So resolving the legacy issues is something that it's really challenging for us. The second challenge is one of the main points of the due diligence process is to conduct an impact assessment. But we must really consider that these impact assessments have to be culturally appropriate. If they're not culturally appropriate, we won't be able to understand the real impacts as understood, as felt by the Wayuu Indigenous community. If this assessment is not correctly done, we will not be able to develop the mitigation and prevention measures required and as defined in the guiding principles. A third challenge that we see that may come up in the future is how to make compatible the Indigenous justice system with the Colombian regular judicial system. The Colombian Constitution recognizes the autonomy of the Indigenous groups and recognizes their own judicial mechanisms. But it's not absolutely clear when one system operates and when another one does. This is not a big issue right now, but because of this lack of clarity, we sometimes feel that this is something that may come up in the future. A fourth challenge that we have identified is that the guiding principles recommend throughout the whole due diligence process is that significant engagement must be carried out with any type of community, and in this case with Indigenous communities. But it's not really clear what significant engagement means. It can mean anything to different types of people and from different sectors. We have seen in this specific situation that the grievance mechanisms designed and suggested by the framework are really helping us not only to compensate and to remedy, but they're also helping us to promote significant engagement with the communities. It's been a mechanism that has allowed us to understand even minor impacts. Even though we are not remedying big human rights violations, we're avoiding any type of escalation of big problems, and we're able to address specific concerns and specific needs. The last challenge I would like to mention is a challenge we find within companies. We know it's not enough to include in our human rights policies to include indigenous rights. We really need to promote sensitivity across the company at all levels on the issues of concern to the Wayuu people, to know their customs, their traditions, their culture, their perspectives. If we do not do that, we will not be able to address correctly the impacts that we cause. So that is a big challenge within the company. Besides these very specific challenges in the implementation of the guiding principles, I would just like to mention other situations that we face that make the situation even more complex. And that is an increasing anti-mining context in the region, a changing and dispersed mining institutions, and the lack of legislation on topics that affect Indigenous communities and other types of communities, such as resettlement issues and also the security risks. This gives a wide spectrum of the challenges faced by by this coal company. I would just like to thank for the opportunity to participate, and if you have any questions, I'll be happy to answer them. Thank you very much.
Ines, thank you very much indeed. For those of you who may have joined us late, and to those of you who may have a burning question but haven't yet alerted Eleonora Aggio to it, this is a lady standing just inside the entrance at the desk. The only possible way to intervene, or to ask a question, should I say, is to identify yourself to Eleonora. If you could do so before the last of the speakers closes, that would be excellent. Next, I'm going to ask Joan Carling from AIPP to give her opening remarks. Thanks.
Thank you. Okay, good morning. Let me, it's working? Let me start from making some context of my presentation. First is that I come from Asia, and Asia is the home of more than 200 million indigenous peoples, which is 2/3 of the world's population of indigenous peoples. We live for centuries in resource-rich areas that we have protected and conserved as the material base of our collective identities, cultures, and ways of life. We, however, belong to the poorest of the poor, most marginalized and systematically discriminated because of our distinct identities, culture, and ways of life. The goals for national development has been used as the pretext for wide-scale land grabbing and massive resource extraction, such as mining, logging, dams, agricultural plantations, palm oil plantations, among others. The realities on the ground in indigenous territories is that most of the conflicts taking place is the result of outright and blatant disregard to the rights of indigenous peoples over their lands, territories, and resources. Mining, for example, are given licenses to, and permits to operate as if there are no indigenous peoples in the mineral-rich areas. Mining areas are now the hotspots of conflicts all over Asia because of the opposition of a lot of indigenous communities, and these are met by militarization and the use of divide and rule tactics, both by mining companies and by the government. In fact, in the case of the Philippines, where I come from, paramilitary forces are employed directly by the companies with the permit from the government, and they are used to terrorize communities that are protesting. And there are several cases already of killings of indigenous activists because of their opposition to mining. The same situation, for example, in India among the Adivasi communities that are resisting mining. Now, on top of this is also the criminalization of indigenous leaders when they oppose this kind of business projects that are not recognizing our right to our lands, territories, and resources. And what is being used are the national security laws, and they call it the rule of law, to brand indigenous leaders as terrorists, saboteurs, anti-development, and use this to arrest, detain, torture, and even kill indigenous leaders who are simply defending their rights over their land, territories, and resources. And this is expected to increase in the context of Asia now that it is seen as the economic growth area with the global crisis, where a lot of investments are pouring into extractive industries, and a lot of the infrastructure developments that are going to take place in indigenous territories. So that is one major challenge in terms of how the respect for human rights is going to be applied in conflict areas. Just to again reiterate that it is actually the gross violation of our collective rights over our land, territories, and resources that is causing the conflict. And that should be the one that has to be fundamentally addressed. Now, the other the other challenges that I see in relation to the guiding principles is the issue of the remedy, especially in terms of addressing displacements as a result of, like, say, dam projects, mining, palm oil plantations, which is now ever expanding in the context of Asia. And since these are forced displacements, meaning that indigenous communities were kicked out of their lands, and on top of that, the compensation offers are very much inequitable or not fair. There are a lot of empty promises, such as, for example, provision for land. The communities are promised lands, but they will not get the same as what is promised to them. The other aspect of this is also that the consent is also taken as an exchange for provision for social services. That communities are going to receive social services like health or employment or livelihood opportunities, provided they give their consent to certain development projects where this condition is not done for other communities. That we are asked to sacrifice the material base of our culture, our resources, in exchange of having social services. So that's completely a very unfair condition that we are put into. Now, the other issue is also in relation to the protection of cultural heritage. I mean, the destruction of cultural heritage is something that you cannot compensate. So business should not be allowed to go, or that these areas should be a no-go zone for business, because I cannot imagine how the destruction of this cultural heritage, like sacred sites, are going to be compensated. On the point of the human rights diligence, what has to be clearly established here is the development of key indicators for the protection and respect of the rights of indigenous peoples, particularly on the land territories and resources, the protection of their sustainable resource management systems, as well as the livelihoods and food security, and the issue of the short-term and long-term impacts. Normally, what is covered in terms of environmental and social impact studies are just the short term. But if you look at, for example, the issue of mining, beyond the mining operation, who takes charge of rehabilitation? Or the issue of dam operation, where the upstream, the problem of build-up of siltation in the upstream is through several years, 10 years or 20 years, and who takes care of that? Who will account for the impact to livelihoods, to the food security of indigenous peoples living in the upstream, for example? So these components have to also be included in the human rights due diligence. And another area which is very critical is the conduct of the free, prior, and informed consent as part of human rights due diligence relating to indigenous peoples. And here I want to stress that this is not only about holding consultations, but more importantly is the process and substance of getting consent, the collective consent of affected communities as a result of a collective decision-making process defined by indigenous peoples and independently done by indigenous peoples. These are the critical areas to make sure that human rights due diligence also account for the social and cultural dimension of the impacts of any business to indigenous peoples. Finally, on the issue of access to justice, indigenous peoples have the least access to justice. And this is because of the non-recognition of our rights. It's not part of the legal framework. And governments would always say, oh, the project can go ahead in your land, because that's not your land. So if you go to complain, nobody will, there's no violation committed. There's no mechanism that will address that kind of situation. And in addition to that is also the non-recognition of our own justice system, our own customary laws on how we deal with conflicts or issues relating to the use and management of our natural resources. Third is the lack of legal aid. There is no provision or mechanism or support for indigenous peoples to make a complaint when our rights are violated, and especially since national legal systems are alien to us. We don't understand it. And if we don't have any legal aid support, how can we even bring our case to the national legal system? And of course, we also have the barriers, like, for example, the remoteness of our villages and the issue of language. National language are not our language. So how can we even relate to a national legal system that we don't understand? So these are the issues also relating to the access, the challenges relating to access to justice. So now I would like to conclude with a set of recommendations. Do I still have the time? Okay, yeah. So first is just to reiterate the point that Jim made on the issue of the collective rights recognition is the legal recognition of indigenous peoples as distinct peoples in relation to the majority and are rights holders, especially to their lands, territories, and resources, cultural heritage, and self-determination, and the exercise of the free, prior, and informed consent. I want to emphasize here that there should be a shift, the mindset of governments and corporations to treat indigenous peoples as rights holders at the outset. We are not just vulnerable groups. We are not just local communities. We are not just stakeholders. We are rights holders. We have our own governance. We have our own territories. So if we are not treated that way, business in indigenous territories will always be a source of conflict. Second is that around this area, there should be moratorium to business projects in conflict areas, especially in communities where projects are being opposed by indigenous peoples. And along this line, specific measures shall be undertaken to address and resolve the conflict with a view of protecting the rights of indigenous peoples and engaging in good faith negotiations to resolve the conflicts. Third point is the pullout of military troops in conflict areas where human rights violations have taken place. And all human rights violation cases should be subjected to the legal system in terms of providing justice to the victims of these violations. Next is the entitlement of indigenous communities to appropriate legal aid so that they will be able to have their concerns addressed. And then also support for indigenous people's capacity building initiatives to promote and protect their rights and to engage effectively with relevant actors and stakeholders. And the conduct of human rights due diligence should include specific indicators relating to the respect of indigenous people's rights, as well as the potential long-term impacts of business projects, especially to the livelihoods and food security of indigenous peoples, as well as on the proper conduct of free, prior, and informed consent. So, thank you.
Thank you, Jim. Next, I'll turn to Megan Davis with a final reminder. If there are questions from the audience, do please register those with Eleonora, who's sitting right up here at the front to the right-hand side of the panelists. Megan, thanks.
I'd like to begin by thanking the organisers for inviting me to speak today at this very important forum, and particularly this very important panel with such distinguished speakers. If one casts one mind back to the prolific body of work produced by the United Nations Working Group on Indigenous Populations in this very building, one can see there is a lengthy history of Indigenous peoples raising their concerns at the UN about the way business, especially extractive industries, conduct themselves with Indigenous peoples on Indigenous lands. And if I look today to the work of the UN Permanent Forum on Indigenous Issues, Indigenous peoples continue to make many interventions about the conduct of business with Indigenous communities and conduct on Indigenous lands, territories and resources. In particular, the conduct of extractive industries on Indigenous lands is frequently raised during the sessions in New York. And since its fourth session in 2005, the Permanent Forum has recommended that private companies adhere to and uphold the principles of free, prior and informed consent, self-determination and accountability in all matters affecting Indigenous peoples' land rights. In any event, this extensive history of Indigenous advocacy at the United Nations about the violations of business against Indigenous peoples explains why it is that the UN Special Rapporteur on the Rights of Indigenous Peoples, the UN Expert Mechanism on the Rights of Indigenous Peoples, and the UN Permanent Forum has focused so much energy on this issue. In relation to implementation challenges, obviously there are many challenges in regard to implementing the UN Guiding Principles for Indigenous peoples. Today I've identified three that have already been touched upon, but nevertheless, in terms of the first challenge, I would identify the lack of awareness and understanding about Indigenous rights. This is probably one of the main challenges of the implementation of the Guiding Principles, the lack of understanding on the part of business of the framework of the minimum standards of Indigenous peoples' rights in international law and how that fits within the broader corpus of international human rights law, and in addition, the role of the state in ensuring protection of those rights. Although there has been substantial developments in the promotion and protection of the human rights of Indigenous peoples in recent years, Indigenous peoples around the world have continued to suffer violations of their human rights on a regular basis, and this is especially the case in the context of the activities of business in general and of extractive industries, in particular such as mineral, oil and gas extraction, which disproportionately impact Indigenous peoples. At the UN Permanent Forum on Indigenous Issues, we hear stories of human rights violations that range from violations of Indigenous peoples' right to self-determination, rights to lands, territories and resources, health and culture, food and water, as well as displacement, and violations of the most basic civil and political rights, such as arbitrary arrests and detention, torture, enforced disappearances and killings, and I think Joan has referred to some of these issues. And women and youth are often in a particularly vulnerable position with regard to the impacts of extractive industries, including loss of livelihoods, violence and impacts on health and well-being. The call to address the problems faced by Indigenous peoples in relation to business and in particular extractive industries has been strengthened by the adoption of the UN Declaration on the Rights of Indigenous Peoples, which establishes minimum standards and provides the opportunity to establish plans and methods to promote and protect Indigenous peoples' rights. So this is probably one of the main challenges, the lack of understanding of this framework of minimum standards. And Jim's already referred to this as a challenge, so I won't say any more. In terms of another challenge I've identified is the lack of understanding around this concept of free, prior and informed consent. And according to the provisions of the UN Declaration, extractive industries must not operate on Indigenous peoples' lands or territories without obtaining the free, prior and informed consent of the relevant Indigenous communities. I've had the flu. Yet what we so often hear is, what does this mean? And to that extent, I would urge business to read the report of the Special Rapporteur on Indigenous Peoples Extractive Industries report, because I think in all the voluminous literature that has been written on free, prior and informed consent and Indigenous rights, this is the most comprehensive, textured and nuanced understanding of what it means and how this may work in practice. What it means will depend on the context or the concrete situation, and free, prior and informed consent cannot be triggered only in the event of the existence of a legislative or administrative right to be consulted. In any event, this leads to a whole raft of other challenges. We now know that due to pressures and struggles by Indigenous peoples, extractive industries are now more willing to consult with communities. And while the level of engagement with Indigenous peoples differs from company to company and also differs from country to country, we are told at the Permanent Forum by Indigenous peoples that in many cases efforts still fall short of adequate free, prior and informed consent. For example, there is a major problem with the lack of full disclosure of information regarding environmental, social, cultural and human rights impacts. A frequently encountered problem is that corporations, in collusion with government authorities, select Indigenous individuals or specific communities with which to negotiate without ensuring that they are represented their communities or the impacted area. And by doing this, they divide Indigenous peoples within the communities. And this has been something that's been quite prominent in the press at home in Australia with regard to mining companies and Indigenous communities. Further, and Jones already alluded to this, that extractive industries often treat benefit sharing or social programs as a charity rather than a human rights issue. And I again referred to one particular comment by one Australian businessman who referred to royalties in an Indigenous community who had given permission for mining on their land. He referred to those royalties that they were entitled to as a consequence of their property right as welfare. In any event, it's also important to point out that the Special Rapporteur, James Anaya, stated in his report that it is misguided to reduce examination of the rights of Indigenous peoples in the context of resource development projects to simply an examination of the contours of a right to be consulted or a right to free, prior and informed consent. And I think that's very important to keep in mind. So finally, the third challenge is again tangential, and that is the implementation gap. Businesses' failure to comply because of non-recognition of Indigenous peoples by the state. We know that the evidence shows that often corporations will generally fail to comply with national laws that protect the rights of Indigenous peoples, but corporations are even less likely to respect the rights of Indigenous peoples in countries where the state itself shows little respect for Indigenous peoples' rights, or where the state maintains close relations with the extractive industries themselves. In some cases, the Permanent Forum has heard examples of where extractive industries are seen to be complicit in the formulation of policies and laws that diminish the rights of Indigenous peoples. And as the Special Rapporteur has already noted, due diligence must be beyond compliance with domestic law. Still, we've heard of some successful cases in which agreements have been reached between companies and Indigenous peoples despite the prevailing legislative framework. Those successful cases are those that fully respect the rights of Indigenous peoples to make decisions regarding their lands, territories and resources, and where they are also beneficiaries of the projects. One example that's been referred to at the forum is the agreement that was reached by Rio Tinto, the mining company, and the Yolngu people of Australia. And this agreement will extend the life of the Rio Tinto Alcan's Gove bauxite mine and refinery for a further 42 years, providing long-term opportunities for education and employment and economic development for the Yolngu. But the mine was established prior to the Aboriginal Land Rights Act in the Northern Territory and had previously operated for more than 4 decades without an agreement with the Aboriginal owners. So to finish, because I've gone over my 7 allocated minutes, it's clear that much work has to be done in order to fully engage business in general and extractive industries in particular to respect the rights of Indigenous peoples. Respecting the rights of Indigenous peoples should not depend only on the goodwill of business. Rather, their activities should be clearly regulated by the national legislation in each country. In the case of a lack of adequate national legislation, it should not prevent business or extractive industries from complying with the international standards as set in the United Nations Declaration on the Rights of Indigenous Peoples. Thank you.
And my thanks to all the panelists for their discipline in keeping to very, very strict time deadlines, which brings us finally to Leo Crippa. Leo, if you could give your remarks and then we'll open it up to the floor. Thanks.
Okay. Well, first of all, I want to thank the Working Group on Business and Human Rights to give me the opportunity to speak in this very important panel. My name is Leonardo Crippa, and I'm an attorney with the Indian Law Resource Center in the Washington office. I'm originally from Argentina, from the northwestern part of the country, from the Jujuy province and the Coya community. I'm going to reflect in my presentation some of the challenges that we have identified in various cases that we have handled representing indigenous communities before domestic courts and within the inter-American human rights system. Throughout our legal assistance to indigenous communities, we have been able to address issues related to extractive industry, logging, and infrastructure projects taking place in indigenous lands. I will not explain the context of indigenous peoples in Mexico, Central and South America, because what my colleague Joanne said regarding the situation of indigenous peoples in Asia is very similar to the situation that indigenous peoples are facing in Latin America. So based on that, what are the main challenges that we have identified? Perhaps I can resume that by saying that the main challenge that we have identified in these countries, in Mexico, Central and South America, is the lack of rule of law, especially regarding private sector projects taking place on indigenous people's land and or affecting indigenous people's natural resources. And what do we mean when we say lack of rule of law? Well, we mean basically 3 things. 1, lack of special legislation, domestic laws, recognizing the rights of indigenous peoples, especially the collective rights that are in play when projects are taking place on their lands and affecting their natural resources. 2, the lack of effective remedies to protect those collective rights. And 3, lack of enforcement of court rulings protecting the rights of indigenous peoples against private sector projects. Let me go in detail about each of these elements of the lack of rule of law. The first one, regarding the lack of special legislation, is particularly important for those countries where the civil law legal system is the one in governing. The reason is simple. Most of lower courts in our countries based their decisions in what is the law, what is the legislation, in the positive law. And so when they don't find a legislation recognizing the right of indigenous peoples, such as the right of self-determination or the right of full collective ownership over their lands and natural resources, or the permanent sovereignty over their natural resources, they won't address those rights as they are recognized in international law. And because of that, we see various implications, especially in those states processes where project proponents are required to assess the project impacts. And those processes where project proponents gets from the state agency a permit to explore and exploit the natural resources located in indigenous peoples' land. Without a specific legislation on the rights of indigenous peoples, especially their collective rights, their rights are assimilated to what has been already said here, either individual rights or the rights of peasant communities or non-indigenous communities. And that is clearly not an effective way to deal with these issues. We have noticed state policies following that trend. We have noticed court rulings assimilating the rights of indigenous peoples to local communities or recognizing rights, but in an individual fashion. And because of that, these countries were brought to an international litigation before the Inter-American Human Rights System. And you can read various decisions from the Inter-American Court simply because there is no legislation, or the decisions that the domestic courts made on these cases were simply not in accordance to international human rights law. And I think this is very important for this forum, given that Principle 11 and Principle 12 speak about the business responsibility to respect human rights. And in those principles, it is made clear that those rights should be taken into account the way they are recognized in international human rights law, or the so-called International Bill of Human Rights. Without specific legislation on the rights of indigenous peoples, existing legislation requiring project proponents to assess project impacts only take into account environmental and social impacts, not human rights impacts. Consequently, processes under these legislations address indigenous peoples within the public participation stages as mere stakeholders, not as right holders. And that situation leads businesses to run into problems. Their projects are facing big challenges simply because the area where the project is taking place, there are indigenous peoples who have rights recognized in international law, but the domestic law is not recognizing that in domestic legislation. The second element of the lack of rule of law it's about the lack of effective remedies to protect the collective rights of indigenous peoples. And the reason is because most of the remedies, as you know, are created in countries to afford protection for the rights that are recognized in domestic laws. And when we try to provide legal assistance to indigenous communities that are facing a project taking place in their lands, we ask domestic courts to provide judicial protection, and they don't find a special legislation recognizing those collective rights. And so these effective remedies based on the existing legislation simply are not effective, and that is something that doesn't provide for a full access to justice systems for indigenous peoples, especially affected by projects taking place on their lands. A third element of this lack of rule of law that we are referring to addresses the situations of the rulings made by domestic courts in cases where extractive industry projects are taking place on indigenous peoples' lands. We have, for example, won some cases in some of these countries, and there is a lack of enforcement of this decision. So this clearly speaks about the lack of rule of law in the country, and that does not give private sector, state agencies, and the people of the country the opportunity to live in a situation where conflicts are not going to be arising. On the contrary, because of lack of enforcement, because of a decision, countries are brought to international litigation before international human rights courts, and this problem must be addressed if businesses and countries are willing to protect the rights of indigenous peoples in the way they are protected under international human rights law. Another issue that I wanted to say in this presentation is the fact that there are in these countries land titling procedures, but those land titling procedures are based on the existing legislation. And as I said, if there is no specific legislation protecting or fully recognizing the rights of indigenous peoples, especially their collective rights, these land titling procedures usually lead to land titles that do not recognize collective ownership over the land. They usually recognize mere use rights for the indigenous communities. Sometimes, and usually, these land titling procedures are way delayed. They do not provide a title in a reasonable time, and the reason is simply because there is a project taking place on the indigenous people's land, or there is a project where there is that is going to exploit their natural resources, and I think this is something serious that must be taken into account. Finally, I wanted to conclude reflecting one of the concerns that we are seeing today, and this is about the multilateral development banks relying more on country systems, their policies and their laws. If these collective rights of indigenous peoples are not clearly recognized in specific legislation so that state policies and domestic courts address them in the right way, these projects funded by these banks are not going to lead to a successful project outcome. On the contrary, we're going to be facing more violence, more conflicts, and more human rights violations of the rights of indigenous peoples. That's basically my presentation, and I'm more than interested in hearing your questions. Thank you.